our partners from Federation of Uganda Employers. I want to say you're most welcome. I say partners because we're all working together to generate a good hope for our country. And we have been working with you. And in the past, we have benefited from the input. So I believe people will benefit from my input this week. We only prayed this morning, so there is no need of praying again. So I now give you the floor. You know the procedure. You know the procedure. You present your views and remember to ask some questions. I now give you the floor. Introduce your members and then present the views.
Thank you, Chair, and honorable members present. My name is Golda Belinda Oboma. I'm sitting in here as the Acting Executive Director, Federation of Ugandan Players, and with me is the team from Federation of Ugandan Players to present the bill to you this morning. And with all due respect and protocol observed, thank you so much for giving us this opportunity to once again, like you said, as your partners, to deliberate on the things that are really crucial to us when foreign labor relations and industrial code is concerned. So my team with me here, I have Mr. Okanya Dan, who is the head of policy and research at the Federation. Then I have the specialist industrial relations and employment relations, Mr. Kabi Godfrey, right on my right. And with me next is yes, Mr. Matovo Michael. Okay, Xavier is Mr. Francis. Yes, please, who's just with us here. And we are the team who have come to give our views to you, and it's a humble prayer that you listen to us and ask the whatever questions that we have, and we pray that we'll be able to answer them. Thank you very much. And with that, I'll give the floor to my colleague to lead us in this. I came with some copies, so we can have copies for the rest of the class.
Thank you very much, my head of delegation. And thank you, Honorable Chair and Honorable Vice President. These are our comments. We went through the proposed amendment bill, and we came up with our comments, which we feel will be crucial and will benefit the amendments. We won't talk much about the Federation of Ugandan Employers. That's just for introduction. But I have to say we are very happy and we welcome the idea of amending the act. And these are our few comments which we came up with. We categorize them into two. We have general comments. The general comments capture areas which were not part of the amendment, but looking into the current act, we found they are very crucial. It's crucial that we incorporate and we extend the amendments to that. And then we came up with also the specifics which are directly at what is in the proposed amendment. We're looking into the name of the industrial code. I use the name of the industrial code itself, and we're proposing that we call it, we change the name to Employment and Labor Relations Code. This comes from the word industrial. In most cases refers to industries, and in the layman's understanding, I may not necessarily understand what it is. So if we call it Employment and Labor Relations Code, it captures and takes care of most of the things. This we're borrowing from our neighbors, Kenya. That's how they have called it. And we feel if we also put it in that way, it will be crucial. The other aspect we looked into is the alternative dispute resolution processes and in most cases, the head when you refer to our Landasa, we're trying to mean labor and dispute arbitration settlement act of 2006. We are proposing that the law should also comprehensively provide for this. We are aware it captures certain aspects, but it's not too so comprehensive. And we're looking into this side to the act, the amendment to give the mandate to have the mediation as a compulsory thing. And this could be facilitated by the employers and the workers' organizations at a bipartite level before a case is referred to the labor officer or to industrial court. And these were the processes which we're looking into. This would help us, first of all, have a backlog of cases in the industrial court being reduced if this mandate is given to employers and workers. And that also means they will be able to establish committees which could be monitored by the labor officers, and the decisions taken could be binding. So it will help us have a win-win, but also make the bipartite spirit, social dialogue take course, and have us an understanding that we shouldn't always be going for litigation. There are issues which we can solve even at the workplace level. A tripartite aspect and arrangement, we are looking into as one of the crucial things which the bill, amendment bill, should really emphasize. And it should be something, I know the arrangements in the so-called setting where we have tripartite arrangement, employers and workers are represented, that should be emphasized more. Labor officers, we're looking into the powers of the labor officers to be extended in addition to what is already provided for, to have them receive complaints, labor complaints, to refer the parties to mediation. Like for instance, if a labor officer receives a case, we'll be able to gauge a case and refer back to these committees and say, well, why don't you go for mediation at the workplace level? Interpretation, there are certain words which we feel they should be interpreted, and that was bipartisan, industrial relations, and the representation, basically. When I was looking at the old act, was not clearly defining these words, and it's important they are able to be defined. When we come to the specifics, we're looking into the function of the industrial court itself. In addition to what is already provided for, we feel this what should also be part of it, dispute relating and arising out of employment between an employer and the employees. That is the NSSF claims and workers' compensation. We have found that in most cases, when a case is referred, it could be within the same transaction, but when it relates to issues of compensation, there are things which are referred to public service and also other industrial court that the other courts, not really handled by the industrial court. So we find that in all cases, the industrial court should be given the power to handle all cases so long as they are within or they are originating from the same case and the same transaction. This will mitigate costs for litigation. Like for instance, someone after going there again will go the other side to incur most of the costs, but also it will consume time before someone is handled. These cases is fully handled. And then we also looked into section 10A. If you look at the proposed amendment, we're looking into this and we're saying it should be maintained that is as it is in section 10(5) of the current act. That should be amended, shouldn't be amended. And that was talking about the time frame, the duration, how long should someone, the period someone should be, the term limit, the period of service. So supposing he's appointed as an employer representative or workers representative, the period. And what we're saying, the proposed 3 years duration here is quite too low, considering the limited number of these people who have such experience, but also when we look at the work they do is more voluntary, and yet the job is more demanding. So if we have them 3 years, that one is off 3 years, the other is off 3 years, the other, we may reach a time where we have again to recall some or appoint someone who is still young, and he may not be able to serve the purpose because he still have so many issues which he has to work on. And then we also looked into section. Sorry?
What is asking how many years would you suggest then?
Oh, we were proposing, because the other order to a total of 5 years, and it was silent first, silent to other representatives, but like they have no term limit in that case. Then section 10B, if you look at the amendment, we are proposing to replace A and B with the word, with the sentence, the presiding judge shall replace the person who ceased to be a member or ceased to be available and inform the parties accordingly. Because what this A and B was trying to talk about, they were talking if the parties to the case agree hearing. It's like a judge has to ask the parties, do you agree? So and so who is supposed to represent employers or workers in this case is not available or assist to be around. Do you agree that we proceed without that person? And then the other parties will say yes or no. So if they say no, they refer. So that will diminish the powers of the judge first, but it also prolongs the cases. It takes time because they have to adjourn and then give another day, yet the case will proceed. So we're proposing that we replace this by that word, so that the judge has powers to replace if there is another representative from employers who is available, who is sitting for that particular file, and the hearing proceeds. Then we're also looking into section 10C, 2 of the amendment, proposed amendment. We should specify the notice period for register for resignation, because the period was not specific. It is only talking on notes, but the period of notes is not there, which means someone may intend to resign and just put in today and says I'm resigning there and there, which means the court will not have adequate time to solicit this person whom we should get. So I think the notes should be there, and we're proposing at least 3 months notes before the person totally leave the case, the court resign. And then we also look into section 10C, 5, and we're saying insert a sentence in consultation with his or her federation, because this particular part was giving powers in terms of removal or termination. It's on termination that a judge may inform, so long as inform a minister, that person's contract or appointment can be terminated. But then we need that word in consultation so that we avoid other things. Such as a federation, if we appointed Mr. Kabi to represent us there, you notify us so that we get to know the issue before a judge forward that request to the minister, so that we are able to understand it. So that is what we are proposing, that particular part. Then we're also suggesting to also insert a word. Yeah, that's the part. Then the other section 41(2), we're proposing to insert the word Minister of Public Service, because it's talking about remuneration. And the remuneration, we felt Minister of Public Service is important in this aspect, that he should also be part of the people who decide, because they are the people who do the remuneration of all the bodies in the public service. So we felt that should be part of it. Those are our specific recommendations, comments and recommendations, proposals In our conclusion, we have to say we are in agreement with the amendment, and we say the amendment should comprehensively provide for alternative dispute resolution as a means of resolving labor complaints and disputes. This means the employers and workers will have to set up alternative dispute resolution committees to facilitate the process. And the resolution reached in these committees should be recognized by the industrial code and should be binding. ADR is more economical other than waiting for ages for the matters to be heard and concluded in the industrial code. It also allows the parties to come up with a win-win solution to the dispute, because if we meet together as workers and we sit together, we're able to have a win-win agreement. The other take, I also take, and we agree. So it can be even more amicable way of resolving disputes in the labor market sector. Those are some proposals we beg to submit to the Honorable Chair. Thank you.
Thank you so much for the submission. I think the points are very, and thank you for your contribution to this important process of making a good law for this country. Members, we have some questions. As members prepare to ask you questions, I have one question regarding the subject of alternative dispute resolution. You can ask me questions. Maybe we may refer to third page. I don't know if all with experience in these matters should they educate me. Is there today an assumption that alternative dispute resolution is already in place or has been tried for and was court? I thought it was obvious. Or under existing labor regulations, one has affect this mediation mechanism. I don't know if it is obvious. Second, we want to establish committees. I want to understand your last sentence. This means that employers and workers will have set up alternative dispute resolution committees for facilitate this process. If you establish committees, it means they have to be established somewhere by a certain section in the Act. They have to be established in the Act. The Act itself must establish the committees. Having established the committees, you must think about the composition of the committees, the functions of the committees, and also financing of these committees. So you think about these issues. Remember, any other questions? I still want to confirm something.
My comment was on the alternative procedure. How different it is from the disciplinary procedures in the Employment Act? But also on the proposal to having the pay procedures. Are you also aware that a number of your members will not recognize unions and have deliberately refused even to sign recognition agreements or to engage into CBR? So how will that apply? Because if you put it in there, it must be applied across. And yet there are just few members, few of your members who have accepted to recognize unions and they have
Okay, maybe we look at page 2. What the is talking about separatism. You said this means representation of employers and workers. Example, in Orissa, how many workers are affiliated to labor unions? Governor South, I don't know. Maybe Kampala, I don't know how many. We need to have some better. The idea of tripartite is going to work. You have some that
Chair, maybe for
it
information.
will be able to cover.
For information, we are aware that there are a number of workers who are willing and even have signed consent forms to join unions. But the biggest problem is the employers have refused to allow members to join unions. And in some cases where you risk as a union to submit a list of your members, the state starts terminating them. So that's why it was very clear that
No, remember, you presented for us, so you must clarify this issue. And with honesty, that's what you want us.
It's in that section C5, on page 3. You spoke of including the words in consultation with his or her federation immediately after the word the judge. And my question is that in this one, almost indirectly remove the powers of the head judge and give them to the federation. If the head judge has first consult with the federation, if unless the consultation is binding, and if that's the case, then it becomes redundant anyway. Consult with the head judge. I don't know if you get my.
Yeah, I get your point.
Are you noting the questions, please?
Yes, we are not.
I'm not okay. Please.
Thank you, Chair, and thank you, Federation of Women Employers. I want to re-emphasize the issue of when you talk of the mediation being set by the employer and the workers. I do not know whether you take an initiative as you and women going down to the grassroots to see the composition of these workers and the people that lead them. Because there are scenarios in some of our country stations or districts where you find someone comes up and is saying he's representing workers, when actually he or she is not within that framework of the workers. So you ask yourself, how do you represent interests of workers when you're not even an employee in a specific organization? Just because someone has come up and wants a position, he says, I'm representing workers. In the last parliament, I remember Bulisa district, the person that was said of the representing workers was actually not from Bulisa district, but was from a different district in Rwenzori. So we have issues of people who are camouflaging to represent workers when actually they're not within the work environment where these people are. So as you look towards this kind of arrangement, I think you need to have a better way of knowing who is who in your framework of workers. And also maybe also to elaborate more, when you talk of alternative dispute resolution process, and you want it to be comprehensive, as you indicated, I think we need to re-emphasize at what level of comprehensiveness do we intend to have this, and be more specific on the exact comprehensiveness that we are trying to refer to.
Until anything, maybe you answer,
Okay.
but we see your main point is about negotiations, encouraging negotiations for going to court, dispute resolution. But you have to bear in mind the component of power relations. Power relations between the employee and employee. Where the employee has no power as in Visa, and only the employers cause the negotiations may not be easy. Maybe somewhere, like here in Kampala, where you have vibrant labor unions, you may see negotiation can ease the work. So I'm sure when we bring this matter in the plenary, members will be keen to know how it will work in practice, especially in rural areas. Which challenges we need to know. So you help us. We think about another Kampala here, where there are strong labor unions that can participate in negotiations. Also think about rural areas where our people may not be in position in trade unions, or to have the power to negotiate. So I hand over to clarify the issues. And the ones they are very good to submit it.
Thank you, Chair. And committee members. Each of us representing here have speciality in this and will answer the questions based on how you've asked them. Thank you for the opportunity. And like you've rightly said, the ADA approach and the negotiations is really part of social dialogue. And looking at the current, looking at the bill in amendment, the emphasis from our side to ensure that this is put there is really pertinent. We already explained some of the reasons from a generic point of view, in terms of not just the cost cutting, but in terms of reducing the caseloads that we have currently. And looking from that angle, as you say that we should break down the comprehensiveness, yes, we're going to do that. And it's a good submission that you've mentioned Kampala's case study, and you've compared it to the other districts up country. Very, very rightly, we like to recognize that most times, yes, you're rightly to say that we have people who do representation and yet they're not actually exactly part of recognized, if I could say. And I think from our part, yes, we're going to share some of the things, initiatives that we're doing regarding that, but also future initiatives that we're having a look at. And I'll give an opportunity to Mr. Mr. Kavi, to just come in from the last question and respond to that. That directly falls within.
This last one?
Yes, please.
The power employee relations?
Yes, please, yes.
Yeah, thank you, Golda. Thank you, Chair. Well, that difference is natural and it will always be there. But the issue when we emphasize social dialogue, then, and especially when we recognize the trade unions, then when it comes to negotiations, we come at the same level. Even during mediations, when we are mediating cases, what we do, we first of all dispel our authorities and we come at the same footing. And that's how we come to achieve a win-win. And I don't think that difference will really be there. Now, when you talk about upcountry, we are encouraging, where we talk to employers, we encourage our colleagues, our counterparts from the National Organization of Trade Unions and COFTU to come in and mobilize the workers. Because the issue is actually, there is a weakness. Of course, as the Honorable has put it, as employers, we cannot simply recognize anyone to represent our workers. Until we have a clearance from either NOTU or COFTU that this is the rightful union that is representing this category of workers, we do not simply recognize. And that's why there is still that challenge. But the unions have also not gone very deep. You find that up country, in Bulisa, for example, you might find it is only UNATU, the teachers union that is there and active. But the rest are not active. So for us, where we have members, we usually invite them. We have an MOU with NOTU.
Yeah.
So I think, and then if we put this in the law, then I think it will even strengthen our relationship. We believe where workers are strong, they even boost us as employers. There is confidence and there is more productivity. And that's what we want. And then as a country, economically we shall improve. I don't know whether I've attempted to answer.
Actually, let me try to give you more light on that specific instance. And also maybe this goes, since our chair is an MP representing workers, you also share this with your fellow colleagues that represent workers in this country. There's something that's going on in this country when it comes to electioneering process. People can do anything to have people on their side. As I did indicate in my submission as I was beginning, is that in the 9th Parliament, Bulisa had someone representing the workers, not from Bulisa, but from Rwenzori sub-region. Then the two, last year when they were trying to, I think there was something to do with the closing some gaps of workers' representatives. I don't know who mobilized them, but they are these people that were picked from communities. They've never worked in any organization, not anywhere. But they're the people right now who are actually representing workers at the district as councillors. Are you getting my point?
Yeah.
So I mean, what kind of workers are we going to have? And how are we going to arbitrate issues between employers and workers. If we are having someone as a leader who is not within the workforce of the workers, so I think we have to go deeper as a federation to dig out some of these things. We need equity, holistically. But if we want to do things just because I want a vote from this region, and therefore I can put in anybody that can be able to give me a vote, then to me I think we're doing a disservice to our people. I'm saying this with all genuineness.
Yeah,
It's because I want to represent. I represent people, and I want every single of the people to be represented effectively. So if it's happening elsewhere also, that is very bad.
Yeah, Honorable, you are right. But I think
You want to answer. But remember, we make our best on the realities existing today.
that's what
The
I
realities on the ground existing today. For instance, we had for it tell MPs that there will be a provision on alternative dispute resolution, and that we hope that labor unions are going to mobilize. Can't say hope labor unions are going to mobilize. You must indicate how many people are going to be captured by this method. Maybe as an option. Okay. Maybe committee can adopt it as an option. Dispute resolution. As an option, not mandatory. Okay, finish your submission.
Yes, Honorable, you are right. But now, on the issue of representation, I think that one is not for this particular law that we're trying to say, propose to amend. For representation of workers, there's the Labor Unions Act, which specifies. But then the challenge is that what is the representation? How many workers do the unions represent today? How many do they have under their fold? And that's how these others come and masquerade. They get free, fertile ground to recruit. And the other issue is our unions in the country, our industry. Regardless of what trade that you are practicing, you may be represented. For example, I can take the example of the Plantation Workers Union. We have engineers, we have accountants, we have doctors, teachers, they are all under the same fold. Now, somebody from Rwenzori who ever worked in Bulisa and is popular there can easily come. So I think that one we should bring it under the Labor Unions Act. And it is, I don't know whether I'm offending the honorables and all the people here. Employers don't control politics.
No,
Now politicians, honorable, just get this one clear. I ever belonged to the trade union myself. I was there many years, about 20 years. Now, many politicians still feel that the unions, the leaders of the unions are monopolizing an area. And some of them are not sponsoring these other categories. So we must collectively find a way to bridge it. But as employers, we shall not recognize, because first of all, for us, the certificate comes from the Register of Labor Unions, who registers the unions. The moment we cross-check and see that this is a genuine union, this is the leadership that is even at the ministry, then we discuss. Now, those who masquerade, that is why some people are still saying that employers don't recognize because of some of those weaknesses.
Sorry, I did not speak your name, I can't introduce yourself. But it's not about politics. We are talking about the Arbitration and Settlement Amendment Bill 2019, isn't it? Yeah, and if we are going to have issues of workers and employers resolved in this what you propose as employment and labor relations courts, then, and we're talking of bringing on table workers and employers. Is it?
Yes.
When we talk of workers, that means we are bringing on board a team of workers that represent the rest of the workers. Isn't it? A committee of leaders of workers. And we're saying now here we are, for example, if there are issues within a particular ministry or department where these people are unionized, if I may say. They're unionized, but when they're unionized, again, the person who seemed to be representing them, so actually within that sector of employment. So how do I speak on behalf of these workers when they do not know the issues that really concern them.
Okay.
That is my point of argument.
Okay.
It's nothing like politics.
Okay, honorable, now,
Are you getting it?
I get
Yes.
that point.
Yeah.
Now, for us, what we have done as Federation and the National Organization of Trade Unions, these committees that we're proposing here, we already have something on ground.
Yeah.
And when we have an MOU with NOTU, and when we are forming committees in a few places, as Federation, we appointed people from our fold, those that we know from amongst the employers. And then we also asked NOTU also to talk through their affiliate unions, and they gave us the people on the committee. The employers are 4. We have one in the northern region, we have one in the eastern region, and we have one in the western region, which is based in Kasese. There are 4 employer representatives and 5 workers representatives. But from the fold of the workers, and they were identified by the unions. So I think when we do that, then we shall get the right.
We try to summarize. We try to stick to the brief.
Yes, yes.
We try to summarize the point. Not stick to the brief, focus on the brief.
Yeah.
The leader of the team tried to finish the questions.
Yes, there's something she mentioned, Chair, and I thought I would give opportunity through you, Chair, if you like, to yes, please. Yes, please, to Mr.
One of you.
Francis.
Okay.
Which is very
Let's
strict.
comment. But MPs want specific comment and solution.
Yes,
And that's supposed to be brief.
yes.
Mr. Chairman,
Because we
Mr. Chair, maybe before we proceed to the next issue, I just wanted to refer you to Section 6 of the Labor Disputes Arbitration and Settlement Act.
The amendment?
Yes, the current law of 2006.
Yes.
Doesn't Section 6 capture what you're trying to put forth about the ADR? Because it's providing for arbitration and conciliation being referred to the labor union before going to the industrial court. It's actually providing for it before a matter is referred to the industrial court. And that brings me to the next question. Wouldn't your amendment fit better under the Arbitration and Conciliation Act rather than under this? Because ideally, if a matter is under the Arbitration and Conciliation Act, then in most cases it does not go to the industrial court. It's handled as such. And I'm seeing Section 6, maybe if I may read it for the benefit of the committee, it provides as follows: reference to conciliation and arbitration agreement. Where there are any arrangements for settlement by conciliation or arbitration in a trade or industry between a labor union and one or more employers, or between one or more labor unions and one or more employers' organizations, the labor officer shall not refer the matter to the industrial court, but shall ensure that the parties follow the procedures for settling the dispute laid out in the conciliation or arbitration agreement which apply to the dispute. And when you look at the first sections, yes, when a matter is referred to the labor officer, the first thing that he or she refers to is to try to resolve, to conciliate, meet with the parties and endeavor to conciliate and resolve the dispute. Then be appointed a conciliator to conciliate the parties in dispute and inform the parties in writing of the appointment. So I would think Section 6 and Section 4 get us for ADR. I don't know what you think.
Okay, our executive council is saying that section already captures the issue of alternative dispute resolution that we're proposing. But if you go back home and see it is not sufficient, write something for us and say it will be crack.
I think it captures, but the matter is the comprehensiveness and how it bindingness. Because oftentimes we have seen this happen, but at times they are not binding.
Okay, then maybe you could also look at the Conciliation and Arbitration and Conciliation Act and we see if that proposal would not fit there.
Okay.
Yes, better, since it deals with ADR.
Okay, remember for every row,
Yes.
we have an area where they say cross reference.
Reference, yes.
Means one act is not read alone. You read one act together with another act to show that it makes sense.
Yes.
For example, labor matters, we have about 5 or 6 acts you must read together. So our executive council being the issue is captured. But if you go back and see what is not fully captured, you write something once and check it will crack.
Thank you, Mr. Chairman. Now, what they are is being raised about the alternative disciplinary mechanism. As of now, there is a lot of backlog, a lot of labor disputes, a lot of complaints have not been handled under the present arrangement. We feel that if the workers' organizations are empowered in the act, and the employers are empowered in the act, the backlog and the resolution mechanism will be more effective and efficient. But as of now, what is on ground, inefficiency, backlog, raising, the people are not being helped.
So in other words, what you're trying to propose is that the act should empower the labor unions.
Recognizing this aspect.
This aspect.
Because at the moment, even what we have agreed, if unless a matter has been referred from the industrial court, a dissatisfied member can still take it there. Yet we want it sorted at this level.
Chair.
Okay, the act empowers the labor officer. It is not to remain mess, but to capture it.
Chair, still on the labor officers' powers, you were recommending that the districts that have labor officers should be compelled to employ labor officers. Chair and colleagues, you're aware that we have many districts here in this country who do not have labor officers, and the challenge is the way to be. So how are we going to make sure that actually every administrative unit, there is a presence of the labor officer to be able to handle some of these things? They are needed. Because we realize that in some of these places, you find the district committee is doing almost everything. So how do we handle this as legislators?
We are now giving work to our clerk. We want a document indicating which districts have labor officers and which districts do not have labor officers. I think as you have raised it here, and it is also be keen to know. Because this bill keeps talking about labor officer, but if you stand up and say there is no labor officer in the district, for what this is this bill?
Actually,
So
Chair,
we get a letter which districts have labor officers and which districts don't have. Then as a committee we can see what to comment else.
Actually, Chair, I think that the right word should be which districts don't have substantive labor officers. Otherwise, when we say labor officers, every district has a labor officer. Because since it was the authority was relegated to the local authorities, they just delegated a probation officer or CDO just to take care. But what happens? They don't even budget for them. Even when there is a budget, they don't access it. And that is why our argument some time back, which is not for this, but I can say it, we had proposed that the issue of labor officers should be re-centralized.
You also was saying that the districts, the DCDO is doing everything within that sector, which is not good.
Yeah.
Mr. Chairman.
Okay, I think our clerk will be trying to identify labor officer within the means as defined in this bill. Labor officer defined in this bill. That we are talking to Dr. Ali there with them today.
Mr. Chairman, the honorable's point of people camouflaging because there are no labor officers in the district, so anybody can pretend. Yeah, so if you put as a proposal, if you follow it, then things will clear the way you are raising. Those issues will not happen.
Mr. Chairman, first of all, I think I will support raising the labor officer position so that they can be equally trained, but the same means of gender. as in the past. Today, some issues are going to senior matters. Some there's a cracks to manage. If you went back centrally, the use of gender, and also that they would train. For example, I worked in labor many years ago, and centrally, use of labor was responsible for all officers in Uganda. They would send me for training to Geneva, whatever, and all of us were trained equally. But today, one is we don't have the importance of labor. You see? So that's why I would recommend regionalizing the function of labor officers. So they will see from the same problem. Secondly, one honorable mentioned the employers refusing to recognize the names. You see, relationship between workers and employers is governed by the use of the government. And the junior answer to that. The employer cannot simply refuse to organize a union without labor coming in. Labor will come in and they have powers to take against any employer who refuses. So the employer can refuse and he has 5 weeks to recognize. Then the government, the labor will come in. They have the powers. They govern the employers and unionizations.
Okay, we have noted. So let's do this. So first, we have another meeting. Plenary Zoom.
Thank you very much, Chair. I think the questions raised have been pertinent. The point to think is our assignment, our take, is the constitution of the ZDR committees, their functions and financing mechanism. And still we will say we'll go and do more research and come up with concrete proposals related to that. They have alluded to what we call the employers refusing, and most of the questions have been ironed. And maybe let me talk about the power of the head judge being
subjected to federation.
Yes, to the federations. I think it will not be subjected to the federation, but the issue is it's very important that we get to know before. I know the judge can have several makers, but the powers and the main decision remain in his hands, his or her hand. But the issue is the federation to know why our representative has been cautioned this way, so that we are aware, and in case we have to appoint another, we take cognizance of such a mistake. But if it's done without our understanding, we may not take care of it next time, even when we are appointing. Our relationship between the employer and the employee, I think that has been alluded to. Employers not allowing organization, I think that has also been talked about. So most of the issues raised, I think it is also, we have also learned something which we are going to take back, especially in terms of how best we work on the labor officers. But I think the point we are creating here is that these other people who are delegated the powers of labor officers are really incompetent. They don't know how to deal with the labor issues. And therefore, even when a case is presented before such a person, it will not be handled in a better way. So it's better if we appoint a person with all the competencies to handle that matter. As a federation, we still thank you for the opportunity, and we are in the support of the bill, and we shall continue supporting government in all its initiatives to ensure we have a better industrial relations, peaceful and harmonious industrial relations. That's our dream, and that's the best way to enhance the productivity on the side of employers. Once our workers are motivated, then productivity goes high, and then profitability will also come in. So that's crucial. We work with you. We are ready. We commit to continue working with you. So thank you.
Thank you, Chair. Thank you, members, for being present here. Chair, as it has rightly been said, and thank you, honorable members, for really asking those pertinent questions. It's opened, like you said, it's opened our mind to this. But one thing that we need to really allude to is however much we work with workers, the point that the honorable raised is very key for us to understand and go and investigate who are these people in the lower districts. But I think that is something we didn't mention, but we commit to doing that. And by the time this will be passed, and we hope that the relationship, not just between you and us, but also within the workers, will be harmonized. Because, like you said, we're working on some partner relations already. So, thank you for this opportunity so much, and we're going to do our homework. And if there's anything that we feel anywhere before, like you said, we'll come back and present it to the clerk as requested. Thank you, Chair, for this opportunity.
Again, thank you so much for so ably representing the Federation. You're very effective representatives of the Federation. Thank you for it, and thank you for your input. It's important we take this. Correct, we wait for your feedback. And if we need to, we may call you again. Otherwise, we now come to the end of our meeting. Free to depart at leisure, but there is also tea and water.